A legal dispute over Gadsden Creek in downtown Charleston is now being handled by South Carolina's highest court.
All parties involved appeared in court today to give arguments to the justices. News 2's Jordan Sayopa joins us live in the studio. And Jordan, this has been going on for several years.
Carolyn, Aaron, that's right. The Supreme Court hearing today is just the latest development in a legal battle dating back to 2021 when the initial lawsuit was filed to protect Gadsden Creek from a proposed development project. Now the justices must decide if a state-issued permit allowing these plans to move forward still stands. The future of the historic Gadsden Creek in downtown Charleston was taken up by South Carolina's highest court Wednesday morning in what's become a years-long legal battle.
We're analyzing subject matter that has been delegated to the Department of Health and Environmental Control by statute that requires expert analysis.
The dispute stems from an October 2021 lawsuit filed by the South Carolina Environmental Law Project on behalf of the group Friends of Gadsden Creek. The group attempted to challenge a permit issued by the South Carolina Department of Health and Environmental Control, which would allow West Edge Foundation to partially fill in and build on nearly 4 acres of wetlands at Gadsden Creek for development. An appeal was filed after a judge sided with the developer in December 2022.
The larger Gadsden Creek, the historic, sinuous, natural tidal feature, was over 100 acres.
Okay.
All of that was filled in, and most of the development in that portion of the Charleston Peninsula is now sitting on top of a landfill.
Attorney Michael Tranum, who is representing the West Edge Foundation, told the justices the 4-acre area is actually a man-made ditch through a landfill, saying the historic tidal creek was filled by the city of Charleston years ago. He also argued against the group's interpretation of parts of DHEC Regulation 3012, which addresses special project standards for tidelands and coastal waters. Attorney Ben Cunningham had the chance to reply on behalf of SCELP, who contended the court did not properly apply the critical area and water quality regulations.
These aren't pristine wetlands, but wetlands rarely are pristine. And then if you're going to get into classification of these are more deserving of preservation than others, that's not what DHEC has done. It's critical area. Critical area is critical area is critical area.
Now, as for what's next, Justice John Kittredge said the 5 justices will discuss the case today. Then a decision will be written. He predicted that could take a few months before that happens. Reporting live in the studio, I'm Jordan Sayopa. Count on 2.